Let's just say you found the perfect condo. It's sleek, it's brand new, and it looks like something out of a magazine. But here's a problem. The person handing you the keys might not even legally own it. And if they miss their official closing date or they never get proper permission to rent it out, you could be evicted before you even unfinish packing. This is a hidden trap of interim occupancy. And if you're not careful or if you're unfamiliar with this period during a builder's construction stage, you could be the next cautionary tale on the evening news because these situations are exploding across Ontario. And more often than not, it's the tenant who ends up getting burned. They're left scrambling for help on Reddit, begging for legal advice, and wondering how they got into this mess in the first place. Ladies and gentlemen, this episode is a must-watch, and I can confidently say there are a lot of realtors out there that don't even know how risky these leases actually are. I'm Linda, one of the Ragona Sisters, and this video is your survival guide to a legal gray zone no one talks enough about, and they should. So make sure to like, share, and subscribe because what you're about to hear could save you from mountains of stress and keep you from losing a home you thought you had a contract for. So across Canada, renting is no longer just a stepping stone. It's actually a long-term reality. And that's why this episode matters, because some of you watching might be in this exact scenario and you don't even know it. And here's a secret most renters don't know. When you move into a brand new condo in Ontario, there's a chance the building isn't even legally registered in your landlord's name. So let's face it, a lot of buyers can't afford to carry the unit while waiting for final closing. This could be a few months. So they ask the builder for permission to rent out the unit. Sometimes they ask, sometimes they don't. Whether it's poor communication, incompetence, or something else. In this example, let's say the builder gives them the A-OK. The early access period is called interim occupancy. The buyer gets keys to the unit but doesn't yet have legal title because the building hasn't been registered. So technically they haven't or they don't even own it yet. They're paying occupancy fees. The buyer's paying occupancy fees to the builder, like rent, but not building equity. They don't even have a mortgage for the property because technically it hasn't closed. So until final closing, they're just a guest in the builder's building. So let's just say a unit during interim occupancy was granted approval for lease. What happens if your new landlord can't close? This is brand new territory for a lot of renters and realtors. Maybe the buyer can't get financing, maybe the appraisal comes in low, or maybe the buyer just walks away. It could happen, and honestly, it's happening more than you think. And if it does, your lease could be worthless overnight or questioned. And let me say that again, you could be living in a condo that legally reverts back to the builder. And that builder, some argue, they have every right to say, get out. Some believe the landlord and tenant board will protect the tenant regardless. But the truth, it's complicated. So let's rewind for a second and get a little bit more context. In most cases where interim occupancy rentals are allowed, you need written approval from the builder. There are no standard forms here. Each builder adds their own clauses. I've seen many builder contracts that explicitly ban leasing during interim occupancy unless you have written consent from them. And if the buyer violates that, the lease could be invalid, even if you signed it, even if you paid first and last month's rent. One wrong step by the buyer, the builder, could jeopardize your entire living arrangement. You're just the collateral damage there. And here's a true story. There was actually a Toronto condo buyer who received interim occupancy and they got permission. They rented it out on Facebook Marketplace and the tenant moved in without any clue. Weeks later, the builder showed up. The buyer had defaulted on closing. So the buyer happened to be, their landlord. So the lease, it's invalid. It's gone. The tenant had to get evicted. There was no protection under the Residential Tenancies Act. Just a padlock on the door and get out by a certain date. This isn't rare, and that's the point of this video. It's not to give you a clean answer because I don't have one. And it's also to show you how messy this can get. Like I mentioned earlier, many claim the landlord and tenant board protects the tenant and that there's a lease in place, but others claim the lease is invalid if the landlord no longer has legal rights to occupy the unit, including contractual agreements with the tenant. See how sticky this gets? I've searched high and low to find a black and white answer for you, but there isn't one. Since the tenant is leasing from someone who doesn't yet have full ownership, your rights under the Ontario Landlord and Tenant Board might be limited or completely unclear, which I found in my research. I've even heard of builders asserting their rights and canceling the buyer's contract because of lease violations. That could mean restoring the unit back to the builder's control and evicting the tenant in the process. You may have paid first and last month's rent, but if the landlord's contract is void or canceled, you could face eviction without any of your protections you thought you had. And then some could argue it could all come down to the exact wording in the builder's agreement. So let's talk through the risks, the gray zones, and the questions you need to ask before you move into any new building. First and foremost, you need to ask if the building is in interim occupancy. If it is, ask these questions. The landlord that you're renting from, do they actually have written consent from the builder to lease during interim occupancy? One big way to determine this step is if you're signing a side agreement directly from the builder themselves. If no such document exists, or if they hesitate to provide one, that's a red flag, guys. Without the official approval, the lease is already on shaky ground right off the hop. And on a side note, I've been seeing some agreements where the landlord adds the builder's lease terms after the lease was already signed. Understand this, it's a violation of contract law. You can't legally insert new clauses into an agreement after it's been executed, unless both parties agree. And if you see this happening, seek legal advice. Number 2, what happens if the buyer of the condo can't close? There will be clauses outlined by the builder in these scenarios. You have to read them very carefully. And if you don't understand them, get a lawyer to help you. I can't stress that enough. Number 3, if the builder takes the unit back, where does that leave you? And number 4, if the buyer goes bankrupt, are you just a casualty? That's another biggie. I found a clause in a builder agreement I want to share with you just to show you how it's been worded. So it goes like this. In the event of the termination of the purchase agreement or occupancy agreement, other than by way of final closing of the purchase and sale transaction contemplated by the purchase agreement, the landlord's right to possession and occupancy of the leased premises shall terminate, and the rights of the tenant to possession and occupancy of the units shall also terminate, and the tenant shall be obliged to vacate the leased premises. There you have it, folks. The clause is pretty clear. The builder wants the tenant out if the buyer is in breach of contract. Whether this is legal or not, it's very messy. The builders make these clauses crystal clear in their agreements, often in all caps or bold text. Let me give you another real example here. The buyer fails to close because interest rates spike since they bought pre-construction. Their mortgage got denied. The buyer breaches the contract with the builder. Guess who gets locked out? The tenant. They lose their home, they lose their moving costs, and guess who the tenant can't sue? The builder. And these are not anomalies. I'm assuming you can sue the landlord, but if they go bankrupt, I don't know what you can sue for. But here are some other issues that come with unregistered properties that you may or may not have thought of. You may not get your mail. Canada Post might not recognize the address until the building is fully registered. Or you may struggle to get internet if the unit isn't fully registered in the municipal systems. And you could also be living in active construction zones with ongoing noise, unfinished common areas, and no working amenities. Pools, gyms, lobbies often closed or not even built yet during interim occupancy. So here's the truth. Renting during interim occupancy can be risky. It could be legal, it could be illegal, or it could be somewhere in the middle. But what it definitely is complicated. There's a lot more paperwork involved. So ask questions, ask for documents, and if your gut says something is off, trust it. If this video helped, hit subscribe. It helps more than you know. And if you have any questions about the Greater Toronto real estate market, we'd love to hear from you. Thank you so much for watching this video, and we'll see you in the next one. Bye for now.